Hi friends from around the world. So the most important articles you should know from the European Trademark Regulation should be Article 7 on absolute grounds and Article 8 on relative grounds. Absolute grounds, that is clear what it means to you, so that is non-distinctive or descriptive as the most important ones. And then you have deceptive against morality or, the general indication or other absolute grounds existing. This is one thing. Absolute grounds is one thing, but the relative grounds is perhaps more important. So one is on the examination, right? The absolute grounds. And relative grounds is once it goes over the examination and goes to the publication. This is Article 8 of the European Trademark Regulation here on the screen. And what says Article 8? Let's go briefly over it. In Article 1A, so Article 8, paragraph 1A, there you have the identity of the goods and services and the identity of the marks, and that is likelihood of confusion, right, is an opposition ground. 8.1b, also likelihood of confusion. We talked about that. 8.2 is about the earlier marks, which can be invoked in order to make the likelihood of confusion happen in 8.1b, right? 8.3 is representative or agent want to make an opposition because of its own right, which has acquired as a representative. So that is 8.3. 8.4 is a trade name or sign in the use in the course of trade. And 8.5 finally is about reputation, which we have already talked about in two videos. Well, you have it on two videos. And that is about the taking unfair advantage and the detriment of the reputation and of the distinctive character and so on. So Article 7 and Article 8. I want to make this clear to you. What is it for today? Today is 8.4. 8.4 is our menu for today, where we have a sign used in the course of trade. And this is about a bit the intertwist between the European law and the national law, which exist and which I would make it clear with this video so that get into your brain. Intertwist, what we have, for example, is a possibility where one sign you applied for is descriptive in, say, Germany and Austria, because it's German language, and descriptive for the goods or services you have asked for. So it cannot be registered as a European Union trademark. Then what is needed is you can make a reconversion into national law, and then maintaining the initial filing date, you can reconvert this into national marks, naturally, without Germany and Austria. But you maintain the initial filing date. So that is a kind of intertwist. Another intertwist is, for example, here in 8.2, where it is said that an opposition can be based on an earlier national mark. So Swedish mark, it can be based on a Swedish mark. It can be based also, naturally, on a European Union trademark. But I want to make here the intertwist of the national mark. And 8.4 is another issue where you have a sign which is used in the course of trade. And I will come into that, but I will line out you the broad lines of the case I want to discuss with you today. This is a case, a Spanish case, and by the way, the language of the proceedings, and it went up until the European Union Court of Justice, is all in Spanish and is published only in Spanish. Why is that? Well, both parties were from Spain, in particular from the Balear Islands, from Spain, the Mediterranean Sea, right? And they agreed upon the Spanish language from the beginning. And probably a lot of lawyers' fees have been has been saved by that proceeding, because it has not been necessarily to be translated into the different languages. If it is translated into different languages, it would be the charge of the European Court of Justice, not of the parties. So the parties saved some money on that. Now, what is it? It is about a trademark which has been applied for in 2012 or so. And then it was about the Palladium, Palladium, Palladium. And this was for services in class 41 and 43. 41 educational services, 43 the hotel services, accommodation, so. Okay. Now in 2000, a bit later, there is a second company also from the Balear Islands, as I lined out before, which opposed, well, it was an invalidity claim, right? Invalidity claim against the European Union trademark Palladium. It was based on the sign used in the course of trade, Grand Hotel Palladium. Both are word marks. Well, no, the first is a figurative mark, which you have seen beforehand on the screen. Okay. What is it now about the 8.4? It was based on 8.4, and it must be a sign used in the course of trade, not only locally. Well, the exact conditions are the following, which are 4, which have been cited by the European Court of Justice. So the earlier sign, Grand Hotel Palladium, must be used in the course of trade, right, in the European Union. And it must have use to the scope that it is not only local, but it has, acquired a certain significance among the country, among one country, for example, or among main region. So that is the two. Those two conditions are European law. Purely. So it's based on assessment with regard to European law. Then we have another two conditions. The sign must acquired according to the law of the member states and used before the application in the trademark application. Yeah, naturally, so it must be earlier, used earlier than the trademark. That's normal, but it must be acquired according to the member state law. And second, according to the law of the member state, the sign must enable the owner to prohibit the use of the trademark. So it is a national law which have to be assessed in order to get to the point you can prohibit if the national law does not say this, then you cannot go against the European Union trademark. So this is because you have a sign used in the course of trade. It is not clearly being said in the European trademark regulation what kind of sign it is. Now, does the judges know the European law of the 27 member states at all time, and perhaps at a moment in time 5 years back when it is required, perhaps at the moment of the European Union Court of Justice, where you have to judge how are the factual elements and the law applicable on a case 5 years previous? No, they cannot. They cannot. And what is the consequence? The consequence is that those who relied upon one condition or the other condition have to prove that these conditions exist. Now, if they rely, for example, on national law, which has been acquired and which gives the faculty in order to oppose a trademark application, a European Union trademark application, then this must be proved by and that's in this case the opponent or the invalidity applicant, right? Now, what does he need to prove? He need to prove that this is the law. So he must present the law in wording. He must present a translation into the language of the proceedings of that law, and then it is up to the other party to argue against and to the judge to assess the final outcome. Now let's come back to the case. It was Palladium, the European Union trademark, and Grand Hotel Palladium, which was the sign used in the earlier sign used in trade in Spain. Now, the earlier sign must be used in the course of trade. This has been accepted by the previous instances because, well, were presented some invoices and some documents which prevent the use of the sign. So it must not only be local, but it must have a certain significance. So the documents which have to be presented by the invalidity claimant in that case must have reference to the sign in trade, to the scale of use, whether it is only in one region, the whole territory, the intensivity, the consistency of use, etc. So this has been all proven by the invalidity applicant. So the European conditions were fulfilled. Now let's come to the national conditions of Spain. And it was about Article 9 Spanish trademark law, which says that you have to, it is a sign which is used, so to say, within Article 9 of the Spanish trademark law. The question here was whether the Spanish trademark law needs to be notorious or not. Notorious means to have some reputation in Spain in order to prohibit the opposition, or in order to make an opposition, to introduce an opposition against the European trademark application or registration. Now, in this case, there were Spanish doctrine by saying one reputation is necessary and other which is not necessary. But the invalidity claimant, it also produced as a judgment from a Balear court, which was final, so it could not be invalidated afterwards, which said, well, this has acquired the quality of Article 9, Paragraph 1, Spanish trademark law. So without being notorious or not, reputation or not. And based on this, the General Court, which was confirmed afterwards by the European Court of Justice, had accepted that this is the quality of the trademark according to Article 9.1. So that was possible. And 9.1 enables that it might be used against trademark, application or registration, so invalidity or opposition, right? So that was the case. What was the result of that case? Well, I told you in the beginning that it was about classes 41 and 43. 41 educational services and 43 is about accommodation services. And in that case here, the earlier sign was used for accommodation services only, and accommodation services class 43 and educational services class 41 were, so to say, dissimilar. So it was the invalidity claim was accepted for accommodation services class 43 and rejected for the educational services in class 41. As regards the signs, well, Grand Hotel Palladium and Palladium Well, there's not a big difference between one and the other. Grand Hotel is merely descriptive, and Palladium is the distinctive and dominant element of Grand Hotel Palladium. So and at the end it was Palladium and against Palladium. So it was an obvious, clear case. Now, one last remark I would like to make, and this is with regard to the European Court of Justice and with a claim which has been introduced by the invalidity applicant. And it's about, it has been introduced by the trademark registration, the holder, so to say, the owner of the trademark, which said, well, there is a case law about intermediate marks. Intermediate marks would mean, in Spanish doctrine, that you have also an earlier mark, even earlier, which is the Palladium also, and would then reinforce the position of the trademark owner. Well, the argument has been raised too late, and that is the outcome here, what has been the finding of the European Court of Justice, because it has been raised only before the Court of General Court. And the General Court is already judicial instance, right? The General Court is only there in order to say yes or no whether the decision of the Boards of Appeal was correct or not. And that depends on the factual circumstances which have been presented before the Boards of Appeal. So it is not possible that you present in front of the General Court new factual elements, because then the General Court had to decide about new things which have not been known by the Boards of Appeal. So this argument about the intermediate marks has been rejected as non-admissible, meaning that for you, what you need to present is all at the least, at the latest, before the Boards of Appeal, because once you go to the General Court, then it is also about what has been presented before and whether it has been correctly assessed or not by the Boards of Appeal. But you cannot raise new arguments, new factual elements, or new doctrine, or new whatever it is in front of the General Court. Only you can, doctrine, yes, but not factual elements. How is that in your home jurisdiction?